I think there's thanks, Chair, there's three questions on Dixon Advisory. Now, what was the total amount of losses in the Dixon Advisory case?
Good afternoon, Senator Bragg. Let me just find my notes because I had rather anticipated you may wish to talk to me about Dixon Advisory. You're talking, just to clarify the question, Senator, about losses overall to the Dixon, or claimed losses overall to the Dixon Advisory clients. I don't think I have that figure here in front of me. My apologies, Senator.
Okay, it was a couple of $100 million at least.
Just actually, I may have it here.
It's one of the biggest collapses in recent years.
Oh no, yes, indeed. So the information I have here is that in December 2022, a DOCA was approved by about 90% of creditors, and that total claims exceeded approximately $368 million. So I think that might be the figure, Senator.
Thank you, Deputy Chair. So a significant collapse, and the settlement that ASIC pursued with Dixon was, I think, in the range of $15 to $20 million, wasn't it?
No, Senator.
How much was the settlement agreed then?
So ASIC took proceedings alleging contraventions of the law. That matter was resolved with the federal court imposing a penalty of $7.2 million, I think, together with ASIC's costs.
Have you collected that money now?
No, as we talked about before, Senator, because Dixon went into administration, we have not collected that.
So that will never be collected?
I think that is unlikely to be collected given the financial circumstances of Dixon. I might also note, though, just on that, Senator, that the court, ASIC, in that particular case, given the monies that were outstanding to creditors, ASIC would have had to seek leave of the court to enforce or collect that penalty, because clearly, were those monies available, they should more appropriately go to investors than into the Commonwealth revenue. Okay. The only other issue, Senator, and I don't think we've discussed this before, but you may well be already aware of it, there were a number of class actions on foot as well, and there was some monies returned to investors through settlement of those class actions.
As you know, we now have a statutory compensation scheme of last resort, and a large part of that money will be going to compensate people who lost a lot of money. So I just want to finish on asking you about, I think ASIC has tried to pursue an action, I think, through a breach of director's duties in relation to this Dixon saga.
Yes, we do.
And I think that there was maybe there was a judgment this week.
Yes, there was.
And I believe the judge said, and I just wanted to get your reaction to this, I think the judge said this case should have been pleaded in the conventional way, not in the discursive way permitted by concise statements. The lack of the discipline of pleadings meant that the trial of this proceeding took a course that was untethered to precise allegations of fact and their alleged intersection with or relevance to the Act, so that a cause that was opened as raising 3 issues was closed on the basis that it raised 16, which is an unsatisfactory state of affairs, to say the least. So it sounds pretty scathing to me. What do you say about this, and what can ASIC learn?
So, Senator, the commencement of civil litigation proceedings in the federal court by way of a concise statement is part of the practice directions of the federal court. ASIC and other regulators use a concise statement as a matter of course, because that's what the federal court has requested that we do. In more recent times, some of the judges of the federal court have formed the view that because the nature of a concise statement, as I think His Honour says in the paragraph you just referred us to, that the precision, if you like, of the allegations being made are not set out with great granularity, as they are in the traditional statements of claim. Some of the judges of the federal court are now saying to regulators such as ASIC, we prefer that you use a traditional statement of claim rather than a concise statement. the particular judge in that case was of that view. We accept that, but I do sort of have to say, though, that we use concise statements because the federal court has requested us to do so.
Well, we only hope that in future we can put more bad people away.
Senator Bragg, you and I are at one on that issue.
Thank you very much. That concludes the time we have for questions.